Hello everybody, it's Walter, your favorite historian, educator, professor, and social studies extraordinaire, here today to discuss with you the case known as ExParte Merryman. ExParte Merryman was a famous Civil War era case decided right here in Baltimore, Maryland, on the issue of whether or not the President of the United States has the unilateral authority to suspend the writ of habeas corpus. If you don't know what that is, the writ of habeas corpus is a protection against unlawful or arbitrary imprisonment. Specifically, it allows an individual who is arrested and detained to challenge the legality of such detention before a judge. At that point, them or their lawyer will present to the judge why the arrest and detention was unlawful. And at that point, the judge will decide whether or not it was lawful or unlawful. Okay, and that is what this case addressed, whether or not the president, in this case Abraham Lincoln, had such authority, unilateral authority at that. Keep in mind the context of the American Civil War. So let's get into it. John Merryman, who is our subject here, would be arrested in May of 1861 for his connection and participation in committing acts of sabotage against several Maryland bridges in the early days of the American Civil War. And the reason he was doing that was to help inhibit the flow of Union troops through the state, headed for Washington and headed further south. So Merryman was arrested in connection to these activities, and subsequently his lawyer filed a writ of habeas corpus challenging his imprisonment with U.S. Supreme Court Chief Justice Roger B. Taney, whose circuit, the Fourth Circuit, covered the state of Maryland. Taney immediately issued the writ of habeas corpus and directed General Cadwalader, who was the military commander in Baltimore, to produce Merryman before Taney the next day. All right, and obviously, so that Cadwalader would not have to leave the limits of his military command, Taney would hold court in Baltimore. All right, so once Cadwalader received Taney's writ, Cadwalader, who was also a lawyer himself, retorted to Taney that unfortunately he could not oblige that writ, as he needed to seek instruction from President Lincoln on whether or not it was okay to release Merryman to go before Taney in the first place, and requested a postponement. Taney said, "Nope, there will be no postponement, sir." And as a result of his failure to produce Merryman as directed, Taney would issue a writ of attachment, aka an arrest warrant, for General Cadwalader, and directed a U.S. Marshal to go to Fort McHenry to serve that warrant. This is on May the 28th, 1861. So, also, on that day, Cadwalader received instructions from the Army Command, from President Lincoln, not to release Merryman. So when the Marshal went to Fort McHenry in his vain attempt to arrest General Cadwalader, of course, the Marshal was not allowed access to the fort. That was stupid anyways. He really thought they were going to let him in there. And he had to return back to Taney empty-handed. Taney, realizing that even though the Marshal could have gotten the police to help him get in the fort, that would have been a lot of violence and chaos, because the police versus the U.S. Army, that's an obvious win for the U.S. Army right there. And Taney, angrily recognized there was nothing he could do, but issued a statement from the bench that the President of the United States had no power to suspend the writ of habeas corpus. All right, and he could not authorize a military officer to do it, and that military officers cannot arrest a person not subject to the articles and rules of war except as ordered by the courts. And that was all he could do. All right. A few days later, on the 1st of June, 1861, he issued a much more authoritative opinion that he would file with the U.S. Circuit Court for the District of Maryland, which chastised President Lincoln for blood, holding that the President of the United States had absolutely zero power to suspend the writ of habeas corpus, that this was a power exclusively vested in Congress, as indicated in the Constitution, with it being under Article 1, which discusses congressional power. He also referenced heavy precedents from the British common law, obviously, from which American common law is derived, that in Great Britain, only Parliament had the power to suspend the writ of habeas corpus, not the king. and obviously translating it to the United States. Only Congress had that power, not the president. So, interestingly enough, Taney's opinion, while referencing other dangerous events of the past, completely left out the fact that Lincoln was dealing with a major domestic crisis here that was unprecedented, and completely failed to take into account the necessity of the president to do what he needed to do to save the country. Okay? So Lincoln himself, on the immediate sense, paid Taney's opinion no attention. All right? He himself was also a lawyer, as we all know, and Lincoln issued a very prompt and very stern argument to counter Taney's. Lincoln said, simply put, that must they be allowed to finally fail of execution? He's talking about the southern states. Even had it been perfectly clear that by the use of the means necessary to their execution, some single law made in such extreme tenderness of the citizen's liberty that practically it relieves more of the guilty than of the innocent, should to a very limited extent be violated? To state the question more directly, are all the laws but one to go unexecuted and the government itself go to pieces lest that one be violated? Okay? Now, it is insisted that Congress and not the executive is vested with this power, but the Constitution itself is silent as to which or who is to exercise the power, and as the provision was plainly made for a dangerous emergency, it cannot be believed that the framers of the instrument, the Constitution, intended that in every case the danger should run its course until Congress could be called together, the very assembling of which might be prevented, as was intended in this case, by the rebellion. So Lincoln is making the counter-argument, folks, that the president of the United States, unlike Congress, is on duty 24/7, 365 days a year. He can respond to the nation's needs immediately, unlike Congress, which especially at that time, if they weren't in session, might take weeks to formally assemble. At that point, whatever's going on might have completely destroyed the whole damn country. Therefore, the President of the United States was in the best position to take the actions necessary to save the United States, ordering the arrest of disloyal and treasonous individuals, detaining people who are engaged in outright acts of sabotage, doing what he needs to do, even if this meant that perhaps some people who might not have been doing anything might get imprisoned. Ultimately, that would all be cleared up. But again, as he makes the argument, under Taney's logic, more guilty people will go free. Under Lincoln's logic, it is almost certain that more guilty people will be imprisoned, as long, theoretically, as you were not doing anything outright treasonous or advocating the overthrow of the government or participating in any treasonous or seditionous activities that clearly indicated you were in favor of secession or the breakup of the United States. You had nothing to worry about, all right? But ultimately, the President of the United States was in the best posture and position to take the necessary actions to preserve, protect, and defend the country from enemies, domestic and foreign, as indicated in his oath, all right? And Lincoln did just that, all right? So the immediate practical effect of Taney's opinion was very little, all right? And to date, it has never been validated or rejected by the Supreme Court of the United States. Several of his fellow Supreme Court justices sitting on circuit duty, by the way, in other circuits throughout the country, did not at all acknowledge Merryman and ruled differently. So a month after this, in July of 1861, Merryman was finally arraigned, okay, and released on bond, okay? And as you would expect, the case never went to trial. Why? Because Taney was firmly convinced that he would never get a fair trial in Baltimore. So using a deliberate stall tactic, Taney kept postponing it and postponing it and postponing it over the next 3 years, okay? And refused to allow any of the other circuit judges to preside, okay? When Taney died in October of 1864, his successor as Chief Justice, Simon P. Chase, also never brought the case to trial. And with the end of the war, the matter was essentially dismissed. Okay. So that, folks, is Ex parte Merryman. And essentially, the irony here is that for all of that Taney was demanding the government prove its case, when they finally wanted to, he never allowed them the ability to do it. So that's it. Any questions or controversies, leave them down below and I'll be happy to answer them. Take care of yourself. Stay safe out there. Professor Shelton, out.